choices you made, say they are for me, but they're hurting me, nobly. Hear my voice, taking action, hate me. I'll fight for your right and power. Breaking taboos till we're free. And there's no empty space between all the words you say and the things I do. Things you do. Let's build a bridge. Build a bridge. Let's build a bridge. Let's build a bridge. Build a bridge. Let's build a bridge. Let's build a bridge. Let's build.
Good afternoon, ladies and gentlemen. We'd like to welcome you to this special CJ session on emergent jurisprudence. Because of the fact that we have all of our guests still scattered around the room, we'd like to ask all of our guests to kindly move to the front. We would love to have everybody move to the front so that we have a nice, neat room, especially for the cameras and for the photos, so that it looks like a beautiful session. So kindly, we ask you to just move yourselves to the front. There's so many seats at the front. So kindly move to the front. We'd greatly appreciate. So, mesdames et messieurs, merci d'être venus ici. Si c'est possible, veuillez s'asseoir tout en avant. So, veuillez s'asseoir tout en avant. Merci beaucoup. So, feel free to take any of the chairs at the front. We'd love you to come and sit at the front. Thank you very much.
You'll always lie to say that you love me, but you don't. 'Cause every time I try to build myself up, you break me down. And I'm so fed up of your promises and empty words. I need more, more. There's an empty space between all the words you say and the things you do for me. There's an empty space between all the plans you make. Say they are for me, but they're hurting me. I see you toil, I hear you cry every day. That you till the soil and give your life, but it's all in vain. And though I try to save you, you're just too weak to fight. Give more, do more. There's an empty space between all the words you say and the things you do. The things you do for me. Oh, and there's an empty space between all the plans you make. Say they are for me, but they're hurting me.
Ladies and gentlemen, I'd like to signal the arrival of our special guests, the Chief Justices from a number of the IGAD states. Let's give them a big round of applause. We'd like to welcome you to this special CJ session on emerging jurisprudence in resolution of land-based conflicts. Let's kindly let our Chief Justices take their seats. We'd also like to signal the arrival of our Minister of Lands. Thank you very much. Honorable Judith Nabakoba, let's give a big round of applause. It's my great pleasure now, ladies and gentlemen, to introduce His Lordship, Justice Tadeo Asimwe, Deputy Head, Land Division, Uganda, representing the Honorable Principal Judge, to take us through this afternoon's proceedings. Let's give him a round of applause.
My Lord, the Honorable, the Chief Justices of different countries. I begin with the Chief Justice of the Republic of Uganda, in absentia though, Honorable Justice Chigamoy Owing Doro, who happens to be the host. My Lords, the Chief Justices present, I can see a number of them here. Our sister from the neighboring country, we congratulate you for having dealt with that important matter concerning the election of that country. I can assure you that in this country, we are closely monitoring what was going on there. And for obvious reasons, you know, all our transit goods go through that country, and we are monitoring should anything go wrong, and we knew whom to ask questions. But thank you for dealing with that question in a timely manner. You remember, Ugandans and members, neighbors, that it happened in what? A timely manner. We were very grateful for it. As we deal with issues related to resolution of land disputes, and I can assure you, land matters are very, very pertinent in the politics of any given country. You cannot divorce these issues we are discussing this afternoon from the politics and governance of any country. So I welcome your lordships, the chief justices, in your capacities representing the judiciaries. And I'd like to say that we're delighted to host you and feel at home. I stand in the capacity of my Lord, the Honorable, the Principal Judge of the Republic of Uganda, Honorable Dr. Justice Zeija Flavia, who is supposed to moderate this afternoon session, and he has delegated me to perform that function. But on a selfish note, I happen to be called Tadeo Asimwe, the deputy head of the land division of the Republic of Uganda, the High Court Circuit, and therefore our daily routine is to determine land disputes. And so it was not a surprise that the principal judge invited me to moderate this session. If I may give you a snapshot of what is happening in Uganda, in this Kampala alone, we're talking about the city where the land division sits. The picture we have concerning the land disputes in a given court, in a division where I sit, each judge, we are around 10, each judge on his or her desk is holding a docket of 1,000 plus disputes to resolve. Imagine Kampala alone. So if you multiplied that by the number of circuits, you can get the picture. We have around 20. So these issues are very pertinent. Honorable Minister, I'm sure these issues I'm talking about is something which is familiar in your docket. We hope to share the developing jurisprudences in this CJ's session, and I hope we shall add a brick at the end of this conference. Colleagues who are here, you'll forgive me, I know there are very many distinguished participants. And for us, by nature, we are buried in courts. We don't get to know who is who. So let me take this opportunity to welcome all of you from different countries in your respective capacities for gracing this afternoon occasion, deliberate on pertinent issues affecting our people. To begin with, my lords, the Honorable the Chief Justice, this is your session. Allow me to invite the regional representative, the regional manager of IDLO to come forward and give us a summary of a report which has already been delivered by the Honorable the Chief Justice of the Republic of Uganda, just to bring us speed as we wait to hear presentation from the next presenter. Welcome.
Thank you, my lord. Honorable Chief Justices here present, honorable ministers here present, judges, all protocols observed. The moderator has invited me to give a summary. I don't think I am qualified to summarize the speech of the CJ. So what I will attempt to do is to remind what were some of the key elements of his speech without summarizing it. Otherwise, I would do injustice to it. The Honorable Chief Justice this morning did very well by us in terms of taking us through a process that really lends us well to then begin to interrogate the emerging jurisprudence. What the Chief Justice did was that he gave us a very detailed historical perspective of how issues around land and land conflicts have evolved, particularly in Uganda, and not just in Uganda, but also the region. From the Chief Justice's address this morning, it was clear to us that the colonial question has had a significant bearing in terms of how land disputes are now resolved and how they have emerged. Central to the conversation and the speech that we received from the Honorable Chief Justice was the indication that in essence, the tenure systems that we had held at a customary and traditional way over the years were severely disrupted by the colonial boundaries, by the colonial laws that were introduced. As a result, the role that the customary practices and mechanisms used to play in resolving land disputes no longer had the power and the recognition that they had previously had. This is something that has continued till today. We heard in the address from the Chief Justice that what has since emerged is various or a multiplicity of land tenure systems and also of dispute resolution mechanisms, which at times are in conflict with each other and which have in a large way got to a point where we no longer recognize the pertinent and significant role that customary mechanisms play. In the address from the Honorable Chief Justice this morning, we heard about how the 1995 Constitution brought back freehold title and in essence brought in a new regime which has also had significant challenges in terms of how the mechanisms have evolved moving forward. As I said, I'm not summarizing, I'm giving perspectives of some of the key elements that were in today's address. And the reason why I'm doing this is to set the stage so that we get a deeper introspection also from the other Chief Justices who are here present, as well as from the Minister, so that we get a better understanding of the elements that now constitute the emerging jurisprudence with respect to managing or resolving land conflict. A key issue that was also referenced by the Honorable Chief Justice in his speech today was how the proliferation of small arms which are associated with the civil wars and the conflicts, the political conflicts that have characterized some elements of the region at different times, has also had a significant impact in terms of how land conflicts are resolved, particularly at the local level. So bringing together all these streams of issues has a significant implication in terms of how we ultimately resolve the land disputes, as I indicated. The failure to be able to register land and land interests was also noted as a particularly important element in terms of affecting how the jurisprudence is evolving here in Uganda. And it is something that also maybe we will hear from the other Honorable Chief Justices, how they have dealt with issues around land titling, in particular also with respect to women and how these issues have been resolved in terms of allowing them to also register title to land. I will not take more of the time, Mr. Moderator, save to thank the participants who have gathered here today and to look to the honorable panel of Chief Justices and anticipate that we will hear today significant contributions from the various countries in terms of how they've dealt with the emerging jurisprudence, or what constitutes rather the emerging jurisprudence towards resolution of land conflict in the region. Thank you, Honorable Moderator, and thank you, Honorable Chief Justices, for the opportunity to stand before you and tease out some of the highlights from the speech that was given by the Honorable Chief Justice this morning. Thank you again.
Yes, it's not easy to pick out points from a speech which is not yours. Thank you so much. Another round of applause to our brother. To run very fast, now that digestion is busy taking its course, we don't want to delay you. At this juncture, we're supposed to have a presentation by Don Dare. I'm told he sent his apologies, and there is an equal representative in the names of Esther, who is at this juncture invited to come and share her perspectives on how the land disputes are being tackled in her presentation. You're welcome.
Wow, there are so many people. So, Honorable Chief Justices, starting not this time with our host, but with the Honorable Chief Justice from my home country, Kenya, Honorable Lady Justice Martha Koome, Honorable Ministers present, Honorable President of the East African Court of Justice, I had seen him somewhere, Honorable Judges of the various states present, Judges of the EACJ, I've not had you being mentioned, but I do recognize you. I had seen Lady Justice Anita Mugeni somewhere, and Johanna Masare, the President Judge of the First Instance Division of the Court, distinguished guests and delegates, all protocols observed. Good afternoon. Good afternoon. So my name is Esther Muigai Mnaro. I always say I'm a Kenyan by birth, a Ugandan by education, and a Tanzanian by love. So I'm at the proper East African. So my topic today was to discuss adjudicating land justice in international and national courts. I purposely will focus on international courts and more so on the African Court on Human and People's Rights and the East African Court of Justice, which is where the organization I work for, Pan-African Lawyers Union, litigate the most at. So to date, Pan-African Lawyers Union has litigated 33 cases before the African Court and 31 cases before the EACJ, making us the highest litigators before the two courts. Among other things, apart from litigating, we do push for development of the legal profession. We are a membership organization. We comprise individual lawyer members and bar associations. We also work in the area of law, peace and security, democracy, elections and governance. And most importantly, we employ strategic litigation as one of our main tools. So to start with, the African Court, I have given a very detailed write-up of how it was established, the composition. Of course, it sits in Arusha. I've also highlighted its mandate is to complement the protective and mandate of the African Commission on Human and People's Rights, the Commission. And the jurisdiction of the African Court is to deliver judgments on both contentious and advisory opinions. And it has really continued to build on this jurisprudence. I have also highlighted the procedure, and because I'm not training lawyers, I will not go through the entire procedure of how you file a case, but it's there in my presentation. I also looked at the East African Court of Justice, which was established under the EAC Treaty, and the court is responsible for determination of disputes that may arise under the treaty. It is therefore it plays a crucial role in conflict resolution. And of late, this jurisprudence has grown to even include land disputes, and why this is relevant to today's topic. So I've also listed how you can file a case before the court and who can file a case before the EACJ. So, and then I highlighted a few jurisprudence on the cases that touch on land that have, not in the very recent past, some are recent, some are very old, that have been adjudicated both before the African Court on Human and People's Rights and the East African Court of Justice. The most recent for the African Court, I'd say, is the Ogiek case, which may be known to some of the people in the room. This was a case against the government of Kenya, in which an indigenous community that had occupied part of the Mau forest had challenged the decision of the court to evict them from the forest, claiming that this was their ancestral land and then they had a right to live on this particular land. This case was filed in 2012 by the African Commission. Why it was filed by the African Commission is because the first complaint had been filed before the African Commission, and it's then the African Commission that referred this case to the African Court for determination. So for this particular case, why I say it's important is because I feel it has contributed a great deal in the jurisprudence of international courts and how they handle land matters. So there were three rulings issued in the Ogiek matter. The first one was on the 15th of March 2013, where there was an order for provisional measures, which directed the government of Kenya to, among other things, stop all land transactions in the Mau and refrain from evicting the Ogiek community from the forest. And then on the 26th of May 2017, the merits judgment was given. And finally, in 2022, what we call the reparations judgment, which is what determines what then the affected people are to get, was delivered by the court. And indeed, the court granted a collective title deed to the Ogiek and ordered the government of Kenya, in consultation with the community, to delimit and demarcate and issue collective title. Among other things, it also ordered the government to compensate the Ogiek community for the loss of property, for the moral damage that they had also incurred during the evictions. I have also listed all the other orders that were given by the court, but to save time, I'll not go through all of them. Another case, recent case on land that was determined by the African court is the Harold Muntali versus Republic of Malawi. This was a case that was brought by a Malawian citizen, challenging how the procedure that the government of Malawi had used to seize property, including land that belonged to his late father. And the court, again, in a judgment delivered in June of 2022, awarded material damage as well as compensation for all the heirs who had suffered prejudice due to how the government of Malawi had conducted this. The EACJ jurisprudence is a bit more wider than the African court when it comes to land matters. And to start with is one of the most contentious ongoing matters now, which is the Loliondo case. The Loliondo case involves the Maasai community residing in the Loliondo area. The case was first filed in 2017 by the Maasai communities. They were challenging, again, the government's directive to evict them from what they call their ancestral land. Unfortunately, when the judgment was delivered this September, we lost in the case. We were representing the Maasai community, but we have since filed a notice of appeal, and we are preparing to appeal this decision. There are two other ongoing cases that are before the East African Court of Justice, still touching, one on Loliondo, in which touches on events that happened when Loliondo 1, which we call Loliondo 1 case, was ongoing. The government, through the Minister of Natural and Tourism Resources, adopted a declaration which demarcated, again, another piece of land from the Loliondo and wanted to evict the government. So then this again gave to a new cause of action, and we filed a new case on that. And then we have what we call the Ngorongoro case. This again touches on the Maasai residing in the Ngorongoro area who are being evicted forcibly. And the biggest reason as to why this again was a new cause of action is because the government of Tanzania decided to stifle the people who live in that area by removing all the resources that were meant to go to the Ngorongoro area and taking them to a different area where they want the people to forcefully move. So in a way, then the people don't have access to either healthcare, to schools, because all the money has been moved. So that is also an ongoing case. I then looked at, yes, fine, we have the capability to file land matters before these international courts, but what are the challenges? And one of the main challenges that first comes to mind is implementation. For both the EACJ and the African Court, we rely very heavily on the state's willingness to implement the decision. There isn't a very clear mechanism of what happens if the state decides, I will not implement a decision if the decision is against me. And in more cases than not, of course, the decisions are against the states because you can only sue states before the African Court, and for the EACJ, you can only sue states and the Secretary General of the EAC. So this has remained as a challenge, but I must say, although it is a challenge, these two courts, I still consider them relatively new courts. They have teething problems, and this is not a problem that is unique to these two courts. And that is why I always say it should not dampen the people's willingness to engage these courts when they have any disputes. If they feel the courts then should address it, they should not think, oh, I'll get a judgment and then what? There'll be nowhere to implement. So I would say that it's a teething problem. And with time, of course, we will find ways on how to handle non-implementation of decisions. And indeed, the African Court, in their new rules of 2020, they have formulated a more detailed procedure of how they can follow up on implementation, just instead of say you report after 6 months or you report after 12 months of what you have done. Other challenges for the African Court, I'd say, is the limited number of ratifications and declarations under 34.6. And also, there have been a lot of withdrawals of these articles. When a state gets a judgment and it's not in their favor, they then withdraw their declaration. And then that means individuals from that particular country cannot go to the court directly. They would have to first go to the African Commission before they can then go to the African Court. And then the other issue that cuts across the two courts is the limited knowledge of the procedures and rules of the court, the lack of the political will to just, push the court agenda ahead. And then there's, of course, the fear of the states to be brought to justice. So they don't like calling each other out, even when some of them don't implement judgments. And then there's also limited knowledge of the ratification process. And I'll give an example of this. Some countries, I think it's maybe that we still need to do advocacy. For instance, the DRC ratified the protocol since 2001, but it is yet to deposit the instrument at the AU level to date. So according to the officials of the DRC, they thought they were party to the protocol. And they even nominated a judge to the African Court, only for them to be told, no, by the way, you're not parties to the protocol. So there's need to also enlighten the states on how to ratify. And then there's also the delays in delivery of judgments. For instance, the Ogier case took about 10 years before it was determined. The Loliondo case has taken about 5 years, and I cannot blame the courts for this. The courts don't have full-time judges, which means they only work during certain sessions. And that is where the question of what more can be done if we want to use these courts to solve more land disputes and more conflicts in the region and any other cases. Although we are making progress and we are growing jurisprudence, not just on land matters, but even on matters touching on other human rights, we can also see there's progress in the boldness of the decisions that the courts are taking. For instance, the fact that the court can now say, oh, by the way, you actually are wrong and you should not have taken that land, like they did in the Ogiek case, like for the EACJ, they have done for one of the cases was against Burundi for a person called Nyogambo Theodore, where the government had confiscated his land and wanted to nationalize it. And the court was very clear that, no, you are wrong, and actually gave compensation. And there was also a case delivered in September, still against Burundi, Francis Ngaruko versus the Republic of Burundi, where again, court actually declared that the government's action of confiscating this land was wrong and ordered for the person to get their title back and ordered for compensation as well. It shows that if we engage the court more, then we will have more avenues and more channels to adjudicate, again, not just land matters, but also other matters that touch on Africa and Africa problems. Because also the Chief Justices are here, I would also take the opportunity to request them, if and when they advocacy to extend the jurisdiction of these courts, that is then indulge us, because it would also help the court in a great way. There are also some few amendments, like on the 60-day rule within which you're supposed to file a case before the EACJ. It's a very short time to research, get funding, and to file a case. So it means it locks out very good cases, some on land, some on human rights, because of the very short period within which you have to access the court. So I must mention, though, apart from this, the court also does issue advisory opinions, the two courts. And we have a pending advisory opinion before the African Court that touches on the land rights and property rights of women in Africa, because based on a study, we realized that about 15 countries in Africa still have very discriminatory rules against women and how they own property. Allocation of more resources to the courts would also be good. So in conclusion, we are Africans, and Africa is our business, and we need to strengthen the African human rights mechanisms we have so that they can play a major role in resolving many of the African problems the people of this great continent are facing. Thank you, merci beaucoup. Degio mono in my language. Asante sana, webarinyo. Have a good afternoon.
I'm sure Mr. Don there, wherever he is, he must be saying somebody is competing for his slot. And please don't report her. Thank you so much. Can we give her another round of applause? Thank you, Esther, for delivering your presentation in a timely manner. We did not limit you, but that was so good, jurisprudence, and we have really benefited a lot. By way of reactions, I think it would be in the best interest that we give their lordships, the Honorable, the Chief Justices, to take on, to give their reactions, their perspective on this very important subject. And without following any protocol, or I know we have the most senior CJs here, wouldn't want to dictate, but we have the Republic of Kenya, we have Somalia, South Sudan, EACJ, and then we have the honorable ministers. This being a CJ session, I think it would be unfair to allow the audience to delve into these matters before the concerned constituencies deliver their deliberations. At this juncture, allow me to, these days, you know, gender issues, the females are running very fast in Uganda judiciary today at a level of magistrate grade 1. When we pass an advert, the females are beating males seriously. I don't know, is it because we are promoting these issues of gender? But allow me, without wasting time, invite the Honorable, the Chief Justice of the Republic of Kenya to give her perspective on the subject. You may opt to stay where you are and deliver your perspective. I will not limit you, this being your session. And after their lordships have given their perspectives, the order is going to be the honorable ministers will also give their perspective, if any, and if they do not have, then we shall come back. EACJ also will have an input, and then the audience. We have a lot of expertise in the room, so we shall give you an opportunity. Someone will run around with a microphone, and then we shall close our session. My Lord, the Chief Justice of Kenya.
Thank you very much, Judge Moderator. Allow me to stand on the protocols that have been established by the previous speakers and recognize in a very, very special way my brother Chief Justices, the Honorable Ministers, judges present, the organizers, and all of us this afternoon. A very good afternoon. Yeah, in Kenya we say, I fear you. So, or I respect you, but now because I'm a woman and I'm a mother, I can even say I love you. Yes, so this afternoon I am privileged to respond to three things as follows. What is the judicial preparedness for managing the impact of climate change on land-based disputes and conflicts? 2, the role of customary and informal justice actors and alternative dispute resolution mechanisms in managing disputes and conflicts around land-based natural resources. The role of the judiciaries in addressing transboundary, cross-border, and inter-community conflicts around land-based resources. And lastly, because I'm a woman, how do we realize the rights of women and girls over land? I will give Kenya's perspective, which is not different from our sister countries. Our major intervention in resolution of disputes and conflict around land-based natural resources is through some 3 mechanisms that we have established after a lot of struggle to make sure that land is accessible for use, and also there is efficient resolution of land disputes. We have done this by establishing a specialized court, which we call Environment and Land Court, at the level of the High Court. It is described in our Constitution as a court of equal status with the High Court. We've also introduced alternative justice system mechanism where we build the capacities of the communities for them to be able to understand their own problems and solve their own problems. And when they do resolve those problems, they bring their resolutions to court and we adopt. We've also adopted a court annex mediation where we assist litigants or those who are disputing land matters to be able to speak to one another through a mediator and find solutions to their own problems. And we have found this absolutely useful, especially in family matters, families that are disputing over land, because their major problem is that they are unable to talk to each other. Although they live together, they take one another to court. So when they come, we don't want to escalate their problem. We give them a mediator who allows them to discuss the problem and find a solution by themselves, which then we as a court adopt and allow these families to live in peace. Our land problem, like everybody, when I listened this morning from the wonderful presentations we had from Uganda, began from the colonial times. But these problems are intractable. They include inequality, concentration of land holdings in the hands of a few. We were told how the colonialists came and took away our land. For us in Kenya, when we became independent, because the source of us fighting for independence was to claim our land from the colonialists. And when we did become independent, there was a Kenyanization system policy that was implemented so that the white settlers who owned our land, large tracts of land, were encouraged to sell to the local people. But this did not bring equality, because the people who were able to buy those tracts of land were now the elite, the Kenyan elite, who are in positions of power. They are the ones who are able to get loans from a body we were calling Agriculture Finance Corporation, which was set up, and Settlement Fund Trusts, which was set up to help with the Kenyanization. There were a few indigenous people also who had a foresight. Although they didn't have a lot of money, they joined into land buying companies, and they were able to buy some of those large tracts of land to divide among themselves, among the members. But greed and corruption crept in, and the distribution of those pieces of land, some of them have remained thorny areas in our courts to determine what shareholding should be given to those people who bought shares in those land buying companies. This has also been complicated, ladies and gentlemen, by a legacy of land grabbing, especially the public land and spaces. We have a serious problem in Kenya where the land that ought to have belonged to the public, held in trust for the public, found itself in the hands of the private developers, who then developed or sold to others, and innocent buyers like the people we call hustlers, who will go and take a loan and buy a property, and then it turns out to have been acquired through fraudulent means because it was public land. So how do you compensate those innocent buyers who bought for value without realizing there was a mistake in the title? So these are the ones we call unresolved historical land injustices. And we also have a serious squatter problem. So due to these problems, the land question has remained very emotive. It is the center of our governance reforms and democratization agenda, which we keep on going since independence. Indeed, land was not only the key reason that informed our struggle for independence, but the land question was also at the center of the constitutional reforms that we engaged in for many years and culminated in our 2010 Constitution. We must remember that land is a finite resource, and therefore its access and use will obviously attract conflicts. And these are the conflicts we have to focus on and see how we can deal with them continuously. We have a land policy which we articulated in 2009, and it is heavy on dispute resolution principles that states, and I quote, "There is a need to ensure access to timely, efficient, and affordable dispute resolution mechanisms. This will facilitate efficient land markets, tenure security, and investment stability in the land sector." This principle continues to guide us. The land policy goes further to impose an obligation on the government to facilitate effective, fair, and efficient dispute resolution regime on our land, and to ensure access to justice in land-related matters. This policy envisages that land dispute institutions and mechanisms will be streamlined through the establishment of an independent, accountable, democratic systems and mechanisms that include alternative dispute resolutions. The Constitution is the one that directed us to this multi-door approach to justice, and Chapter 5 of our Constitution is all dedicated on land and environment. A very, very expansive regime on land and environment. In particular, Article 60 states and encourages communities to settle land disputes through local community initiatives that are consistent with the Constitution. The reason why we return everybody to the Constitution is so that we do not get communities that come and introduce principles that are alien to the Constitution, especially principles that run parallel to the principles of human rights and principles of equality. Article 67 establishes the National Land Commission, and I saw the vice chairperson of the Kenya National Land Commission present in this congregation. And their mandate is to initiate investigations on their own initiative or on a complaint into present or historical land injustices, and they are supposed to recommend appropriate redress, and also to encourage the application of traditional dispute resolution mechanisms in the land conflict. And that is why we in the judiciary are working hand in hand with the National Land Commission through the alternative justice system to ensure that our own people find solutions for these historical injustices. I will also mention Article 159(2) of the Constitution that gives us the authority as the judiciary. The authority we derive from the people directs us to use alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms to promote justice. Pursuant, therefore, to these constitutional edicts, we in the judiciary have embraced this multi-door approach to justice in a bid to realize the vision of an accessible, efficient, cost-effective, and expeditious system of justice. So let me speak a little about the alternative justice system, the one we call AJS, which was activated as a policy, and we launched it in August 2020. We are now rolling it out throughout the country under the stewardship of the National Steering Committee on the implementation of the alternative justice policy. It is led by a Court of Appeal judge the Honorable Professor Justice Joel Gogi. This recognizes that going back to pre-colonial times, African communities have had mechanisms of resolving disputes outside formal state institutions. This has come as a very painful realization that we cannot discard our own systems that we used and they worked to resolve our own disputes. As at now, the NJES mechanism is operational in 3 counties, Isiolo, Kajiado, and Nakuru. Steps are in motion to roll it out in other counties. We have 47 counties. So ladies and gentlemen, my lords, you know, it's a tough job to roll it out now to the other 44 counties. It is important to point out that the Kajiado NJES model is specifically focused on the resolution of land disputes, and we recognize the role that IDLO, who are the organizers of this conference, are playing in helping us put it together. We've also been working with UNODC to implement this NJES model. I'll also share with you our court annexed mediation, where we have been able to operationalize the system in 94 court stations all over the country. This includes 22 court annexed mediation centers that are operating within our environment and land court stations, and 28 before the magistrates' courts, who also deal with land. We started referring land disputes for mediation 2 years ago, and so far 1,400 land disputes have been referred to mediation, and 500 land disputes have been settled and consents recorded as judgment of the courts. When we looked at the estimation of the value of the land matters that were settled, it is equivalent to Kenya shillings 500 million. Allow me to speak a little about the Environment and Land Court, which is the major court that deals with the land matters. It is established under our constitution as a specialized court. And the Constitution states, I quote, the environment and the use, occupation, and title to land is their jurisdiction. Pursuant to this constitutional edict, the Environment and Land Court was established by an act of parliament in the year 2011. The court has powers to deal with disputes related to land administration and management. It is also empowered to hear cases relating to public, private, and community land, as well as contracts, choices in action, and other instruments granting enforceable interest in land. The court exercises appellate jurisdiction over decisions of the subordinate courts and local tribunals in respect to matters falling within its jurisdiction. Some of these tribunals include the Land Commission, the National Land Commission, the Business Premises Rent Tribunal, Rent Restriction Tribunal, National Environmental Tribunal. In 2015, the Environment and Land Court was amended, Act was amended to allow the Chief Justice by the Gazette notice to appoint certain magistrates to preside over cases involving environment and land matters of any area of the country. Appeals on matters from designated magistrates' courts lie before this court. For us, the establishment of the ELC court, as we call it, was informed by the increasing number of land cases. Our colleague here was talking about 20,000 cases. That is how we were reeling under every backlog of cases from undecided matters. Now we have 51 judges sitting in this court and just dealing with land matters. At the moment, we have 39 court stations where they sit all over the country. They are not only in Nairobi. We are now in 38 counties. We hope to be in the 47 counties. Our vision to have an ELC court is actually in all the 47 counties in the near future. So the overall total cases initiated for the ELC courts in the country for this financial year, 2021-2022, were 6,401 cases. In 1 year, we had 6,400 cases filed. During the same period, we were able to resolve 8,600 cases. At the end of the period, right now, what is pending before all our courts as land cases, before those 51 judges, is 14,405 cases. The principal judge of that court was present, but I think he excused himself for another meeting. I would like us to appreciate him because he tells me in the next 1.5 years, they are going to clear this backlog of 14,000 cases, and they are going to be real time. In other words, they are going to be waiting for people to file cases, they hear them and conclude them real time. We need to appreciate them. So that is our environment and land court, which to me is a game changer, supported by the other mechanisms of the land commission and the tribunals that we have. But allow me also to say something about the land rights for women and girls, because land being what it is, women have been discriminated over the time, and also girls from inheritance and all that. The land policy identifies amongst the intractable problems relating to the land question the fact that culture and traditions continue to support male inheritance of family land. This speaks to the broader concern about customary practices that discriminate against women in relation to land ownership and inheritance. We still go back to our Constitution, Article 61, which provides that elimination of gender discrimination in law, customs, and practices relating to land and property in land is not acceptable. So how do we make this constitutional provision a reality so that our women and girls are not discriminated on the basis of culture and traditions? This principle is reaffirmed in Section 4 of the Land Act that stipulates the guiding values and principles of land management and administration. In particular, Article 68 of the Constitution instructs Parliament to legislate on land and regulate the recognition and protection of matrimonial property, in particular, the matrimonial home, during and on termination of marriage, and also to protect the dependents of deceased persons holding interest in any land, including the interest of spouses in the occupation of land. This morning I heard the speech of the Chief Justice of Uganda say that we have an obligation to protect the rights that are registered and the ones that are not registered, i.e. beneficial interest of the people who have lived on the land and they derive their livelihood from the land. The Land Act also, for example, protects the matrimonial home from dealings except upon obtaining of spousal consent for validity of any dealings with the same. But we are inundated by so many transactions that are done without the spousal consent. And when you investigate and do due diligence, we're finding that men are hiring women to go and give consent, pretending that they are the wives, so that the rand can be changed. So that is something we are dealing with. So our courts have developed progressive jurisprudence that affirms women and girls' rights to land. For example, equal rights as beneficiaries when we are dealing with matters of succession. The judiciary and stakeholders in the justice sector and rent sector were key participants in coming up with the Constitution. There have also been key stakeholders because we have one paramount principle in our Constitution that requires public participation when these laws, policies are being passed. This ensured the inclusion of progressive provisions, including those that seek to enable efficient resolution of intractable problems like conflicts. That is, in brief, what we are doing in Kenya within the judiciary to protect and promote justice within the land sector. I thank you so much for your attention.
Thank you so much, the Honorable CJ Kenya. Indeed, you have demonstrated that you really love us and you're a mother, going by your presentation. Can we right away run to the Republic of South Sudan?
Good evening, my brothers and sisters. With all your protocols observed, I greet you all in the name of our Lord Jesus Christ. I don't think I have much to say because when I saw the program, I didn't expect to be asked to say anything. But since I have been asked to do so, let me just say, it is my belief that all conflicts relating to land have something to do with our mindset, the way we think as individuals, the way we think as a family mindset, or as a section, or as a tribe. We begin to describe a certain land as belonging to this family, belonging to this section, belonging to this tribe. We forget that we have gone beyond this kind of situation. We are a nation. Even you talk of a community, for example. Take Kampala as an example. Is it one tribe that is there? Go to Nairobi, go to Juba. I think we have gone beyond this family kind of mindset. We have gone beyond this tribal mindset. And if at all there is a conflict relating to land, we have to be mindful about the public interest against private interest. If you consider this, definitely you will find a way relating to land. And it is this public interest that ought to override the individual interest, in my opinion. Take an example. If we want to dig a canal in order to channel the water through a certain area, in order to avoid destruction, whether animals or people. This is public interest. Can it not be done because a certain family says, no, 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 we don't want this to be done? This used to be our ancestral village. Suppose we want to erect as a nation an airport. Certain groups or families say, oh, no, no, this has been our grandfather's place. They are even buried here. We don't want the airport to be done here. Or say you want to build a school for the future. Children who are not even born, they will go to that school. And somebody says, no, 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 this cannot come. This is our ancestral home. You want to make a road passing through certain villages in order to improve the security, the economy. Then certain tribal minded people come forward and say, no, this has been our ancestral place. No road can pass here. Suppose oil is discovered in a certain area and companies come, they want to dig the oil in order to benefit the whole. Somebody can come forward to say, no, that kind of mindset, we have got to put it away completely. When we are talking about land disputes, we have to consider this public interest compared to individual interests. In this way, I think we will find the way forward. I heard something before that when we were in the other hall, something about the land belongs to the dead and the unborn. The dead and the unborn. What about we who are around? We ought to plan for ourselves. If we do that, then we will have lost the interest in our nation. We are already in the form of nations or countries, and that by itself is above individual interest. It is true that sometimes you have got to consider individual interests. You compared, but if it is necessary, the individual is affected by that kind of planning, then you ought to consider some kind of compensation, whether it is in cash or in kind. But if the choice is between the public interest and the individual interest, you just say bye-bye to that individual, whether you are sitting as a court, as a judge, so that you decide in the interest of the general public. This, I think, we can do at different levels, whether at our state levels or even at the regional level. What is in the best interest of East Africa, for example, compared to the best interest of Uganda or South Sudan? We go for East Africa as a community. These are the few things I would love to say, my brothers and sisters. I did not prepare for a speech. Thank you.
Thank you, Honorable CJ. Indeed, when you speak from your mind, it's better than a prepared text because that speaks to the heart. We need to run very fast. I can see so many people are urging to make their inputs. I'll straight away go to, I don't have names to me. The only Chief Justice remaining now in front here. We don't need to vote. My Lord CJ, you can give your inputs now.
Thank you so much, moderator. Honorable Chief Justices, and Her Excellency, the Minister of Housing, Land and Urban Development, other distinguished guests, all protocols observed. Good afternoon. I don't have much to say because as the previous CJ mentioned, when I see the program, and I thought that I have no intervention, so I didn't really prepare. But I think Somalia is an exceptional situation compared to other sisterly countries, because really Somalia has been going through chaos and loneliness for at least 3 decades, and the institution is collapsed. You know, when the central government collapsed in 1991, all the land deeds may have been left behind when the people fled their homes. And really, there's no land registry in Somalia, and at some parts of Somalia. And as you all know, many parts of the country are controlled yet by the terror groups, Al-Shabaab. And really, Somalia have a very outdated land laws. I think the last laws have been adopted in 1982, after almost 40 years, and have not been yet amended, reviewed, or developed. And in Somalia, really, we don't have yet land policies and action plans or strategies. And still, really, but we do have, we solve the land disputes through the formal justice, the courts, although the country has really adopted a new system. You know, Somalia has been a unitary system of government, but we have really shifted to federal system, and the judiciary is not yet federalized. So there are really, federal member states, which are each has its own judiciary. So really, the institutions are very weak, and the legislations are also quite weak, and still we don't have really policies and strategies and action plans to handle the land disputes. And really, the most complex and sensitive issue in Somalia is the land disputes. And the land disputes sometimes really generate a deadly clashes between the clans and tribes, particularly in the rural areas. And because as the Chief Justice of South Sudan mentioned it, and you know, the tribes and clans believe that they own the land as community, as clan, as tribe, not as individuals. And the government has not yet regulated the land. So really now we are struggling to come up with the policies, to review the laws, and to come up with action plans to handle these land issues. So hopefully in the near future, Somalia will be able to come up with the required laws, policies, and strategies to deal with the land disputes and land conflicts. Thank you so much.
You see, when you are crying that you've lost one limb and you reach a hospital and find a patient with both limbs off, you stop crying very fast. I was about to start lamenting when I had the Honorable CJ of Kenya telling me that 51 judges are manning land and environment court, when in a division dealing with land where I sit, we are only 8. I was about to start lamenting, but after hearing Somalia, I stopped very fast. So our brother here, as you can see, you know, war is very bad. Trying to build institutions, trying to ensure that the judiciary works. So really, this partnership, that's why I don't know if the minister of, in charge of this integration business is around. That's why the integration aspect and the East African community becomes very vital. Our brother here needs a lot from the partnership and indeed a lot from such conferences in order for us to run at the same speed. We are with you, my brother. We shall be there. It's a matter of time. Thank you so much. Very fast, EACJ, if that person is not here, I will quickly run to the honorable ministers. I don't know who wants to take the microphone. We have, I was very happy to hear that there's a debate here of environmental court, and I think the judiciary of Uganda is seriously taking up the matter. I don't know at what level it is. And I think if that court was established and is equipped with the requisite number of judicial officers, almost half of our backlog will go. So for me, honorable ministers, as you have your inputs, I would love to hear where we have reached in that demand, because for us as judiciary, we are ready for that court. And if you asked me for my proposal, is that you establish a court with its own appointed judges. Don't borrow the existing, because the existing is very little. I don't know what the policy makers have to say, but it is really a welcome court. Honorable Minister Judith Nabakova.
A very good afternoon to you, ladies and gentlemen. My name is Peace Regis Mutuzo. I am a Minister of State for Gender and Culture in the Ministry of Gender, Labor and Social Development. I first of all want to observe the protocols as earlier stated by other previous speakers and welcome our brothers from Somali for joining the East African Federation, and also for trying to put up whatever they have done to try to get out of conflict. They have been in very pathetic situations, but want to congratulate them for the journey so far made. And we see them in all conferences, and they are involved in many activities, meaning they are ready to learn, they are willing, they want to put up systems, so anybody with the ideas that can support them would be more than willing. As the previous speaker stated, I was about also to come with my anguish lamenting about the situation of women. And today I want to present on perspective of women. To begin with, during conflicts, either war conflicts, tribal conflicts, civil conflicts, the rights of women and youth, I wouldn't say would be the last to be thought about, but they are not thought about at all during that period. But want also to recognize that the colonial masters or the colonialists held these countries for 70 years. And by the time they left, the policies, the laws that govern us up to today had been designed by them. Our independence, for example, in Uganda, has just celebrated the 60th independence. But even the 1995 Constitution, which was made to liberate women to begin with, let alone all other people, has now moved us for 35 years. Within the 35 years, where at least some bits of transformation that we enjoy right now were stemmed, was an affirmative action, which included and factored in women, youth, and many other vulnerable persons. I want to present on the perspective of a rural woman. We have beautiful laws, policies that are inclusive at the national level. But when we go down to a villager who interacts with the land that sustains us, that feeds us, the women and youth don't seem to enjoy these laws and policies as much as the elite do. A number of factors curtail that transformation to reach the grassroots. One of them is commercialization of justice. any lawyer that stands within a case where land is involved intends to reap big, either hard cash or will want or has an interest on that piece of land. You will correct me if I am wrong. But that's how far justice is. If justice is commercialized, then how just is it? The bulk of work in court. If you have 70 cases to hear, the land cases take so long. Sometimes people die along the way, and they have to bequeath their children to take over those cases. But they also go along with lots of conflicts that transcend through societies, communities, families, until people don't want to see each other or see each other's face anymore. There are also various classes of vulnerabilities. While we talk about women generally being vulnerable, the most rural ones are more vulnerable. The person with disabilities, I don't even want to state. The youth, the children. They also keep challenging issues concerning the family head. Within our laws, the intestate succession law, we have a definition of a family head being a man. But in Uganda, 30% of our families are led by women. Either the men died or women have had children from different partners, or they have chosen to make their own families, because men are also scarce. We are 52%, women are 52% of the total population. So even if you pick to one man, one woman, so where would the balance be? So in that circumstance, would they not find families? Certainly they do. And would there not be a leader? Certainly there will be. So the family head in the courts of law, I don't know how they define it, but even during recently when we were discussing about the parish development model here in Uganda, we're starting a parish development model, there was a suggestion that the family head should be the ones to get the money, which is going to start capitalize the families. Until I shot it up to say, no, the family heads are defined to be men, but there are more women who are heading families. And for a fact, right now with the economy, the way it is running, women are more active. One of the speakers here stated very clearly that why is everything about women now? They are loyal, they are active, they are trustworthy, they work very hard because of the responsibilities attached to them behind. A man can afford to leave home, perhaps without even food. But the woman has responsibility to ensure that she provides not just one meal, but 3 meals to every member of the family that day. She has no escape route. Now, the customary law, in my view, needs to be reviewed, redefined. I think the other important issue we need to tackle is how these cases are developed. First of all, in our police, out of 100 policemen, there are 7 or 8 women. 8. So from the time you begin reporting a matter, you are reporting it to a person who is going to draft it in his own way and understanding, but will also have this patriarchal feeling about it. I recently went to a district to rescue a girl who was being compelled into marriage at age 13. And the police officers nearby, when they were developing a statement, they murdered the whole case. When I was the complainant, a minister responsible for gender. So if they can brave up to that situation where I am present there, then by the time it reaches the courts of law or the Chief Justice, you should know how many people have interfered with it. I think we now need to do a policy review crafted to suit our own situation right now, and not necessarily go benchmarking to Germany or Europe or wherever, to the people who do not even own land, so that we look at the land use policy in a better perspective and lens. Where we are looking at growing horizontal, we need to now grow vertical. Because the land is not growing any bigger, but in Africa, God has blessed us with the capacity to produce more children. In Uganda, we can afford to produce 7 every woman. Because we have food, we are settled, we have peace, there are educational services and the medical services. So the population is growing very, very fast, that we must look at the land that sustains us right now. Sensitization is also one critical issue. I don't know why the lawyers and maybe the health practitioners keep much of their knowledge to themselves. I don't know, maybe it is a way of survival. And the way they are trained is that don't give away your legal information free of charge, isn't it? So these vulnerable women and children, how else will they ever get to know that they even have the rights or the law protects them, if sharing the knowledge alone must be at a cost and a very high cost? So are the medical practitioners. They don't advertise their work, they don't advertise their drugs. So prevention of medicine from prevention of diseases is also becoming very difficult. So until you are sick is when you go to consult and somebody earns. But that also pushes us to more vulnerability and poverty as women and as people who have not necessarily gone to school. The other thing I think should be worked on very quickly is about innovations with a gender lens. Many of the innovations that come up for agriculture are skewed towards use by men than women. How many women would afford to get onto a tractor and drive it all the way? But we know women are the ones who till the land, 80%. So if we took advantage of them by crafting something that is easily usable for women, I think it would relieve them of concentrating on farming and get into other businesses as well, but also do farming better. And maybe strong cooperatives that protect shareholders, where everybody should really become a shareholder, such that the laws, the policies protect every individual, both men and women. And I think it is critically important also to empower men. Lately, we have advocated so much on women's rights. And so men have retaliated by pushing us the corner with patriarchal feelings. And that's when they go back to the law. So we need to relieve our boys and men of negative masculinity, so that we look at each other as partners in development. I have seen my brother running back to the podium very quickly, and I hope it is not a patriarchal issue, so that I stop talking about women and women and women. But at least where I had reached was that I think it is good to adopt new and good practices. And I wish that the alternative justice policy that we have learned from our brothers and sisters from Kenya should be adopted here in Uganda, because not everything can really comfortably end within the courts of law, in the confines of the justice and laws and policies that are designed or were borrowed. Otherwise, we'd lose the peace in our family. So mediations would be encouraged, and I think shortly we'll be coming to you, my Lord Justice, to learn from that new idea of the alternative justice policy. I thank you so much.
The Honorable Minister, by name, she's called Peace. So you can see how she loves peace. And if we must clap the men here, they have lectured on us. You should also clap for peace, because she has advocated for men what? Did you hear that one, men? Yes, empowerment of men. And by the way, it's a serious matter, Honorable Minister, for us who sit in courts. These days, we are hearing criminal cases of sodomy. We are hearing criminal cases where women take advantage of a boy child. These are realities on ground. So it's not a joke. We would want to see women jumping on the top of the roof to start roofing these houses. In this country, in the northern part of this country, the ladies do it. They ride bicycles, they prepare meals, they do all those things, and the communities have not collapsed. Honorable Minister, we thank you for advocating for policy change and innovations. And the comment that lawyers, money, they need to get money, that is a training. But the intervention, Honorable Minister, is pro bono services. We have what we call pro bono services. The lawyers will tell you that it's high time, as countries, we started looking seriously at a legal aid policy where the government, in its budget, plans and prepares to pay for lawyers to defend these vulnerable groups, men and women we are talking about. Honorable Minister, yes, in Uganda, for example, I think we have taken strides. This document is on paper. We don't know in which corner it gathered some dust, but it is somewhere. I would want to hear someone who is in charge to tell us where the National Legal Aid Policy something. It is a long name, but it's something in Uganda which is on the road, which we need to fast track. Because once that one passes, there will be a token to these lawyers to provide free legal services. Peace happens to be my neighbor in a certain district because I come from Fort Portal. And therefore, I'll be very glad, because in my earlier days of work, I was providing free legal services under legal aid project of the Uganda Law Society. I did that work a lot, and I know what it means. Now that I'm a judge, I can no longer do it. But I thank you so much, Honorable Minister. They were very good, insightful thoughts for us to think about and digest. On that note, the Honorable Minister, Judith, did you delegate fully, or you have a few comments to make?
I may be having a few comments.
Thank you so much. It's your time to do so.
But I'm not going to take a lot of time, because most of the issues have been talked about by my sister Mutuzo, my Lord, the Chief Justices present, and members. I want to thank you for the comments you've made during this meeting. As a minister responsible for lands, I want to assure you that I've picked some insightful information, and I believe it is going to help us in the ministry as we move ahead to do a number of reforms touching land matters. I know we have been talking about population pressures, and they are not only in Uganda, but even in the region. Currently, if we say we are at about 43 million people, then our projection is 70 million, probably by 2050. But remember, land is static, it's not expanding. I believe we need to begin looking at land use plan, physical planning, as we address the question of land, to plan for the population now, but also for future population. We are moving into industrialization, agriculture, ICT, services, but things be put. How about the environment? Because I know we are also talking about environment. As the population grows, there is encroachment on our forest cover, on our wetlands. How should we protect what has not been encroached on? What should be the method of protecting probably what we have for now and for the future? As dealing with land, I've realized there are three major issues, and I normally talk about them, which disturb us. The first one is ignorance. People have talked about it. People don't know their rights, they don't know the law. Meaning that in the course of our work, we need to find ways of educating and sensitizing, because if somebody is empowered, I believe they can defend themselves in one way or another. Then another thing is corruption. Corruption is eating us a lot. A poor person to get justice in courts of law, it's a tug of war. That's what people say. If you're a poor person and you hear that your case has gone to court, you just do prayers. You need to find ways of praying such that probably it lands on a good judge who will give you some fair hearing. But that is the talk, that it's hard for a poor person to get justice. Then if a case is in court, it takes 20, 15 years. But remember, this is a land case. We are saying land is life, land is everything, it is the air we breathe. But meanwhile, the vulnerable are taken to court for 15 years. And at times they are taken to court, then courts give, should I call them directives? You know what you give. What? Injunctions, directives. Imagine telling a poor person who has grown up in an area, you are not supposed to do farming, you are supposed to live, you are not supposed to do ABCD. People become desperate at the end of the day. They become desperate. It becomes very difficult, even for us who are in government, to protect the vulnerable. And remember, we respect courts of law. When a matter is in courts of law, you are like, we don't want to interfere with the judiciary. Let's allow them to operate. But even at the rate of disposal of some of these cases, the rate is too slow. But now the judge talked about the numbers. I've just learned that they are few compared to what the colleagues in Kenya have, meaning that we need to speed up to the game. Maybe to find position for the land and environmental matters, because they are quite unique. The same courts in our districts that attend to other criminal, civil matters, they are the same courts that handle environment and land cases. Meaning that if somebody is not interested in attending to a certain case, it may take ages for it to see light at the end of the day. Then we have also started seeing greed as another third element. People who want to have more, they can manipulate everything to make sure that at least they get chunks and chunks of land at the expense of the vulnerable. But here we are stressing land tenure security for everyone. We want everybody to be free, to know how to use their land without any interference, without fear of being evicted. But then we have people who can work out the system and then get titles for the land. To the justices who are here, we would request you that please give some of the cases the due attention they deserve. If it means once in a while stepping out of your good office to visit the locus, please do it. Because I believe when you go on ground, you'll be in position to appreciate. You'll make a fair judgment if you go back to office. Because the person who has brought that case will be the person to feed you with all the relevant information at the expense of thousands who did not even make it probably to the courts of law to explain their side of the story. But if you give us that opportunity, that you visit the different areas to study, interrogate further a matter, then I believe that fair judgment will be delivered and the people will be protected in one way or another. We have still seen squatters who are not registered. Yes, we call them squatters, but they could be having some interests on that piece of land, much as they are not registrable interests, but they have an interest on that piece of land. Some of those people could have been born from those areas. Maybe they were given part of the land. They have stayed on the land for 20 plus years. But because I, Nabakoba, got a title in 2020, now I want to evict everybody who has stayed on the land for years and years. Don't we have laws that look at limitations? What time should somebody could have stayed on a piece of land to render some interest for that person to be known that at least they are staying on a piece of land and they have been there for some time, rather than rendering them squatters? We don't know them. And remember, our registration systems, the squatters are not put on the title. If the title is in my names, it is in my names, and it is covering a number of square miles. The other people who are settling on my land, they are not documented. I think we need to look at ways now of beginning to document people who are on the various pieces of land. Register them, know them. They may not be having a title per se, but at least if they are known and they are placed as an encumbrance or something on a title, then any other party who will be interested in using the land will know that I'm going to so and so's land, I want to buy this piece of land, but there are other people with a different interest. Then, how I wish you could also deliberate on the issue of compensation. We are losing a number of cases in courts as government. And me, I thought judiciary is part of government. But I'm sorry, but we lose a number of cases. And even the fines placed on government, they are too huge. Cases are lost every other day. And we have never been told where is the problem, where is the mistake. Because we lose a number of cases with fines. You realize that there are debts incurred out of those cases. I don't know how this session can help us to plan better and see probably how the legal brains in the respective ministries can work to see that they save government of these losses. Because the losses mean a lot. To me, they mean a lot. And I believe even to government, the losses mean a lot. So would be more than happy if you can tell us, where is the problem? What can we do? We have the issues of alternative dispute resolutions. How can we use them? How can we ride on that? Probably maybe to save on the cases that take long in court where we get losses. Can people be like encouraged to dialogue and handle their matters amicably before probably ending to courts of law? Because they might go to courts of law, it might be a loss, it may take time. And remember, we are looking at using land to do productive work. We are looking at land to do development. But if there are court battles, there are disputes every other day, it becomes very difficult for us to achieve what we want. As government of Uganda, we started on titling and giving the vulnerable land plus titles to make them have their tenure security, but it cannot be rolled out because it requires a lot of money. We are doing it in a few areas, but we hope that once we get cost-effective ways of surveying land, then it might speed up the process of registering people who are supposed to benefit from the exercise of titling. We have the land information system. We are trying to put all our records on the system. And we believe that by putting all the records on computer, on the information system, then it will help us even to clean and reduce on double, multiple titling of one piece of land. We believe that this system will help us to detect, but also to protect even the protected areas like water bodies, forest cover, wetlands, because once the coordinates are captured for such areas and input onto the system, then when a title is being created, alerts will always be raised, and they will help us to know that actually you are doing something which you are not supposed to do. Can you please amend and remove the wetland, remove the forest area, remove the lake, so that we protect those other natural resources. I once again thank you for the opportunity, and I hope to learn a lot from this meeting.
Oh, a round of applause to the Honorable Minister. We certainly share your pain when you are dealing with that docket. It's not a simple one, but we know that with the current processes that are going on of computerization, some of these issues will go away. In Uganda, we are trying to computerize, we are trying to register and give the customary owners certificates. I don't know the exact name, but there is a name which is being given to customary interest owners. I always see certificates being handed over. But Honorable Minister, the biggest challenge right now in Uganda, in my own perspective, is in respect of dual ownership of land, where an unregistered interest by law now in this country is recognized and is superimposed on a registrable interest, and the two are almost running equally. But this day, the unregistered interest has more advantage because it's digging, planting maize. The title owners cannot even step there, and so the fight starts from there. So in our courts, we are seeing more of that, and that's why, Honorable Minister, you say that judges should step there to go and see the gardens of cassava, to go and see. There is a practice direction by the Honorable the Chief Justice that every land dispute should be concluded by going there. Yes, we go. I personally go. But I can assure you it is very tough. It is extremely tough. When we go, we have even discovered that a person with an unregistered interest who entered somebody's land yesterday, he will show you a heap of soil and he will call it a grave. We have seen. The one who entered yesterday, I liked the 20 years of the Honorable Minister, because when we go, we ask you, how old is that structure? Then you find a house with brand new iron sheets. And he says, I'm a Kibanja holder for 30 years. For us, we write it down. And so, Honorable Minister, judiciary is not part of government under the principles of separation of powers. And it is an adjudicator of these disputes when government is fighting with another entity. The judiciary is in the middle of these issues. It's an arm of government operationally. So we don't want the media to capture it that the partner states here have fused executive with the judiciary. I hope that is not the perspective. And it wouldn't be a nice one, otherwise we would be in trouble. But thank you very much for those insights. And that's why we are here to share views in order to come up with good innovations which will help our nations to come up with the policies which will help us really to solve these disputes and live harmoniously and peacefully. It is time. We are doing badly for the audience to share your insights. I think we shall have to resolve on how many questions we need really to put to this gathering, because it's quite big. We can agree to have 2 here, 2 here, 2 here, because we are seated in columns. And then I would like to request somebody to run around with a microphone. Anybody with a microphone? I will start in this corner. Preferably a lady and a gentleman. Yes, I can see a hand in the corner here. Anybody with a microphone? You seem not to be having a microphone. Yes, this is Dr. Sylvia.
Yes, thank you,
Yes,
my lord.
Sylvia, your insights.
I work for the network of Delegate Service Providers Network. So, Honorable Minister, there is a network there giving legal aid to the poor and vulnerable. Thank you, my lord, for the opportunity, and also to my lords, the Chief Justice, for very insightful sharing that you've given us. I have comments, but also some kind of recommendations. We've been talking about some of the causes of land disputes, and we've been speaking about historical injustices, and we have anchored it into the colonial era. I would like us here gathered to be able to think of how to address the historical imbalances, so that each time we gather, we don't lament. We have our own countries in our hands, and we know the sources of the conflict. We need to address them so that we stop saying this was created by the colonialists and deal with them as they emerge. And I would like to say that the alternative dispute resolution mechanism is one of those methods that we can adopt. I've been intrigued by the Honorable Chief Justice of Kenya that you already have a policy on alternative dispute systems. And I think as countries like Uganda, we are lagging behind. We have traditional methods of dispute resolution. They bring about restoration. They bring about community ownership. And we've already heard that land is held in trustee for the community, the future, and the ancestors. So if we are to deal with historical imbalances, then we have to exhaustively utilize ADR and traditional mechanisms of dispute resolution in land, because they know the history of the various communities. I would also like to say that we need to strengthen the legal aid support and advisory services. My lord, you have rightly said so that the governments are lagging behind concerning the legal aid policy and law. Kenya is already having its act. Tanzania has its act. If I may say, it is Uganda that is lagging behind currently. And I want to call upon the ministers to look at that policy that has been at the cabinet since 2012. Since 2012, the legal aid policy, and try to provide for access to justice for the poor and vulnerable, so that we can enable adjudication in a fair manner. Because there is no justice where someone is there and has no one to hold them by the hand. Access to justice means we provide the legal and advisory support services to those who cannot afford, in order for us to be addressing the imbalances, especially when it comes to securing land rights. I'd would like to speak to having simplification of land procedures. We've had the ministers talking about the issue of delays in courts of law because of the injunctions and other temporary and permanent injunctions here and there. We need to simplify procedures related to land justice so that we can make adjudication much simplified. We need to emphasize the issue of specialization, as we've heard from Kenya. We need to have those courts. We used to have land tribunals in Uganda, and they were closed off. But we need to rejuvenate that aspect and have specialized courts that can adjudicate on land matters, but also having community representation. I hope this can be a good way to start with as we deal with the issues affecting land. Thank you.
Thank you very much, Dr. Sylvia. I saw a hand in the middle here. Yes, there are 2 hands, both of them gentlemen. Let's start with the one in front, then the next behind. Yes, this is a hand also. Okay. Can we have a microphone here, please? Here.
Thank you very much. I'm called Robert Lado, the chairperson of the Land Commission, Republic of South Sudan. I'm impressed by the presentation of Kenya because the other two countries would have been alerted earlier so that they come with a position paper. So I'm not going to react in a vacuum. I'm impressed that in Kenya, we have a special court for environment and land, because land is very complicated that we need to take care of. My question to the Chief Justice of Kenya, who is a very brave woman these days in the region. We are not talking about elections, but it's still land. In Kenya, if you are acquiring a piece of land, you said Article 68 talks about matrimonial property or home. Should you buy a piece of land, you can co-own it jointly with your wife. Does it extend to the community land so that if I marry a wife in the urban areas, we'll have a joint ownership of that piece of land? What about my piece of land in the community? Will she also jointly have it with me? And how does it contradict with our patriarchal ownership, where in some communities is the man that owns the land, but I know the community land is collectively owned by all of us. This is number one. The second question is the alternative justice system. The alternative justice system, I know in different countries, my sister has mentioned, in Rwanda, Kachacha has taken a drip hole, but if it is taken, when does it become an order of the court? When the award is registered, it becomes an order of the court, or that system is running parallel, but part of the same legal system. Thank you.
Thank you so much, Honorable. Can we have this is Walter?
Yes.
Yes.
Yes, my lord. My lord, the Chief Justice is present. My name is Walter Okidiladua. I'm in legal practice. I've practiced for the last 33 years. And I have been involved in land disputes, handling them in courts, advocacy for many years. So I want to make a little comment, but first I wanted to respond to the minister, but I think the response has been sufficiently given. When Legal Aid Project was started by Uganda Law Society, I was the council member responsible for it, and he was one of our project advocates posted to Kabarole. Since then, we now have offices of Uganda Law Society in almost every region. Every district is having Legal Aid Project office, which is providing these services for free to the indigent people around the country. So we are not quiet, we are doing something. Particularly the women are the best beneficiaries. Now, I want to come to the presentation by the Chief Justice of Kenya. You see, in relation to women and land, there's something we have in common. The Constitution of Uganda and the one of Kenya, there's this presumably quiet provision that this Constitution is supreme and any custom which is inconsistent with the Constitution shall be null and void, to the extent of that inconsistency. Very good. That law sounds nice. You come to ownership. The law says everybody has a right, the Constitution, everybody has a right to own property without discrimination, men, women, everything. Now we come to the Land Act, and even the Constitution, they still say you can own land either individually or in association with others. It goes still, the land is still nice. Now you come to customary ownership. Yesterday we had here that still about 90% of all the land in Uganda is under customary tenure. Under customary tenure, we know that the traditionalists believe the land is owned by a clan. How do we fit the women into this equation of communal ownership? How do we isolate the women to have individual rights to ownership, which will definitely be fighting with the communal interest. How do we ensure the women have equal representation in the clan ownership? This will play into eventually succession. If a woman gets ownership in this land, can she pass this land to a person of her choice outside the clan that originally owned this land? Can she pass it to her brother, for instance? Can she pass it to her nephew on another side? These are practical dynamics we have with customary tenure, which I think it needs time and legislation to slowly have a transformation so that the issue, it does not bring a fight, but it brings a slow and proper integration of all the purpose so that we are all equally operating within. Because we're not going to change customary law soon. We cannot, now we have customary tenure at the same level with freehold. If they are at the same level, you may transform this one to that, but it keeps its original character of communal ownership. So this is the dilemma we have in the legal system, which I hope Parliament will eventually, unfortunately, the senior minister has left, but the other minister is present. I think some of these are urgent things that needs to be taken to Parliament for further discussions so that we find a proper resolution. The contradictions in the Land Act and the Constitution needs to be resolved. Thank you.
Okay, thank you, Walter. There was a hand in front here. Can you bring the microphone here? Yes.
Thank you, moderator. By name, I'm David Karuvanga, Member of Parliament, and I also chair the Committee of Physical Infrastructure that handles all petitions on land conflicts which are referred to Parliament. Indeed, I'd like to thank the Chief Justices for the presentation. I just, maybe I didn't get it properly, but I would have loved to see the structure of management of land conflicts, because here in Uganda, there was a proposal, there were district land tribunals, but somehow they are conflicting with the courts. And of course, the registration of land is decentralized to districts, and we thought land tribunals would resolve land conflicts, but the problem has persisted. So if maybe I would have loved to know the experience of some other countries, how they've managed these conflicts, especially at the lower levels. Thank you.
Thank you. I'll move very fast. There's a gentleman in the middle here. Yes, there's also a hand of a lady in the corner. Yes.
Thanks a lot, Fidel Masengo from Rwanda. I'm not going to ask many questions, but I just give an insight on the best practices we can learn from our context. Actually, since 2011, we've conducted the systematic land registration. And during that process, at the beginning, we had all around registered, but around 1.5 registration went into dispute because people had customary land rights or had, transaction which was not registered, and many issues linked to polygamy and many other factors. So I'm just starting to say that when you start registration, you will face issues. That's when you will see that there are many disputes that are not recorded. On another note also, I want to just give some comment about the very good presentation made by the Honorable Chief Justice of Kenya about the threefold mechanisms that are used to solve land dispute. Actually, in Rwanda, we do have the threefold mechanism. On the forefront of the mechanism, we use what we mediators, abunzi. Community mediators is a mechanism, it's a homegrown solution that's inspired by the customary law, whereby elected mediators from the lower community at the cell, village, cell, and sector level, which is the lowest entities of the administration, are the people to solve dispute on land, because they know who owns the land, they know who has been there for long, they know all kind of transactions. And this has solved issues of land at, I can say 80%. You just have few cases that can be referred to court. So that's a very efficient mechanism that can be used because the local population, all of them, community is really involved. The second mechanism that is also being tested now, it's the court annex mediation, as you've said. And nowadays, this system is also operating, and people don't want to go to court for land dispute. They prefer to go to mediators. Those are professional mediators, and so also quick. When it comes to courts, of course, we do have also possibility to go to court for few cases that have not been taken to those other two mechanisms. But I have a question on that aspect, because you said that you have specialized court, but when you see land, it's a cross-cutting issue. You will have land dispute in the family, you will have land dispute based on like expropriation, land dispute based on inheritance. To me, if you have a court that is specialized to land dispute, it will be overloaded with cases, rather than leaving the matter to other courts, all courts, rather than having only one single court. You can do that for commercial courts, but when it comes to, probably because we are of civil law, but you will have all cases involving land at a certain point. Let me just conclude on this aspect also of gender equal rights. And this is to court. At community mediators, that is mandatory in our constitution. You have to have female members. So this protects women. You can't have a panel of mediators composed by only men, because our constitution has decided. And in the practice, we'll have like 60% of mediators are women now. So you understand that there is no possible, way of being discriminated. But when you go to court, you will find that they are de facto union, whereby people have lived together without having any title and sharing land, and especially when the husband wants to quit the wife and marry another woman. So we didn't have protection, but now our gender-based violence law has settled that if the de facto women can also access land from the people they live together. So I was just trying to say that you can learn from our context, because for the last, I can say 12 years, we've been developing policies, and on ADR policy, so we have ADR policy that provide for legal aid, and the government is committed to put money in the legal aid policy. And we have also what we call in Francophone acronym MAJ, Maison d'Accès à la Justice, which means Access to Justice Bureau. Those are people paid by the government to just help the population access justice. And they are lawyers, all of them. And you have them at each layer of administration. I just want to give my contribution about this. Thanks a lot.
Oh, thank you so much. It is a mouthful. I hope our rapporteurs are capturing those innovations from that country. There's a hand of a lady in the corner. When she's done, unless there is a burning one, we're overshooting in terms of time. Is that burning? It cannot wait. Okay, can we have the lady and we see whether this one is burning or it's mild?
Okay, good afternoon. My name is Pamela. from IIRR. I think I was reiterating what he said, and I don't want to repeat, but I want to emphasize the role of using community-based structures for land administration in strengthening them. From our working with the on certificates of customary ownership, supporting communities to access those certificates together with the Ministry of Lands and other entities like UN Habitat, GOTN. We've seen that when you strengthen these community-based structures, you have less disputes. For example, the community-based mediation committees that he has talked about in Rwanda, we have also set them up, and we have seen that, and they've also been trained by JLOS, which actually has accredited mediators, court mediators, and we've seen that there's a huge opportunity, but also big gap in terms of what these mediation committees know, in terms of the knowledge gaps around especially legal issues, what you described as the issues that you grapple with even as judges at your level, they also have to grapple with that at their own level, around customary ownership. Can they pass on their customary rights? Some of these things need to be cascaded to the lower level. I think the Honorable Minister talked about the rural woman. What do these laws and policies really mean for people at the local level? So until we begin to translate these policies in action to make sense to people at the local level, it's going to always be an issue of having backlog and more backlog, with the national court system. So I think a key recommendation here should be how the government can strengthen community-based mediation and legal structures that are already taken care of under the various policies. Thank you.
Okay. As you might be aware, this conference has been run both physically and on Zoom. I've been notified that there are some people online who would like to air their views. So can we give an opportunity of 2 questions from those who are on Zoom?
Yes, please. Yeah.
Your name, please.
My name is Sahar Jallad from Palestine. I am a former land administration projects director and advisor to the land authority chairman. Yes, I need to confirm what the last colleagues' contribution, that when we have legal aid for vulnerables, it helps a lot, because we had this experience in some of the projects between 2013 and 2015, when we had assigned some legal advisory to those vulnerable groups and women. It helps a lot. But after that, while now it's running like a large-scale land registration project, when we have many settlements court, but the problem that a lot of cases is condensed on their desk, because we don't have enough qualified judges to solve this issue. So the concentration on having the legal aid to the vulnerables and women and youth is very important. On the other hand, my question or contribution is, if you are going to surveying all the land and to give the people rights, and as it has been mentioned at the beginning by the first presenter or second presenter, that if you want to go in this way, it should be procedures or system established who can, for whom the land can be registered. If the people using land, but the land, as it has been mentioned, is registered in other people's names, if you go to the formal registration, then it will be registered to the people that already own it. So should be a system and procedures or bylaws about if the people use the land, for how much time they use it, so it can be registered by them. Otherwise, you could, these people, vulnerable, could be deprived from their rights to the use of land. So the system should be put before going on this large-scale surveying or systematic registration if you want to protect women or vulnerables or those people, scooters, what we call them, that they use the land but without title. So it should be agreed on some system or legal or procedures. If anyone using the land for 3 years, for example, so we can register the land on his name. Because we have this experience as we working according to the Jordanian law, but you know, in Palestine we have another problem now, that if the laws, if you're using the land for like 5 years, it should be registered in your name, even though if you don't have title. But our case, because we have occupation now and all these land have been declared as a state land, we have this other problem. So I'm going to give just this contribution to advise you people, if you don't have this system on place before going to the formal registration, so it will add another burden on those people that using the land, and they may be kicked out of their rights in using this land. So systems should be in place before starting this big surveying and systematic registration process. Thank you.
Thank you so much, Joran, for your contribution. Can we have one last online? We agreed to. They are done. There's nobody online. So we're going to have this gentleman as the last contributor. Then if their lordships and the honorable minister on this side have anything to come back, we shall give them an opportunity. If there is none, we shall close the session. Very fast, your names and your contribution.
My name is Isaac Galiwango, Monitoring and Evaluation of International Development Law Organization. I have just a comment and a question. In all that has been discussed in the region and in Africa at large, it would be good that we interest ourselves with what happens before and after any intervention to promote access to justice in terms of results. We should pick more interest in understanding the repercussions and the results of our interventions to the vulnerable. Sometimes we could be doing what we're doing and then we're exacerbating the vulnerabilities. And it is from that comment that I raised a critical issue, which is in the region and Africa at large, which is developing. That is the issue of estate developers. We cannot conclude the issue of discussing land management and access to justice without talking about estate developers, who are a new concept in our region. This, we are learning to live with it. And we cannot say it's bad, but we know the extremities and the vulnerabilities that it is posing to our population, our men and women in the region, where you find a place that is supposed to be a forest, and in the middle of a forest, the estate developer comes and he says he's developing plots and he's advertising them as if they're in the city center. And in the process, the issue of land use planning is all affected. And here, I would ask experiences about regulations and policies around the region that maybe we can be able to adopt. Thank you.
Thank you so much. And I think, ladies and gentlemen, I will now find out from the Honorable the Chief Justice if they have a comeback.
Maybe I can respond to the matrimonial property, customary land versus community land. Yeah.
Yes, go ahead, Honorable.
Yes, thank you very much for those comments and very, very insightful views and questions. There was a question from, I think, the chairman of the South Sudan Land Commission, and also from Mr. Water about the same issue of community ownership and the supremacy of the Constitution. Let me start with the matrimonial property and whether customary land or customary property or ancestral land is part and parcel of the matrimonial property. That was the question, I guess. This is a developing area of the law, and in Kenya we have jurisprudence where a woman got married and settled in the ancestral land. She gave birth to children, they built a home, they developed a farm. After 20, 30 years, she is being kicked out. And when she asked, what is my share? She's told, no, this is ancestral land, it belongs to my grandfather. You cannot get anything. And the courts have gone to examine the share, the equitable share that can be given to that woman, even if the land belongs to the clan. And the court has established that a woman can actually claim direct and indirect contribution of ancestral land. And the courts go into that, sign out how much her contribution. And once it has been assessed, she can be compensated with money to go and buy land elsewhere and build. Or she can be given an acre of that land or a share of that land. It's all about equity. It's all about justice. The other problem comes with inheritance, because our law, our constitution, does not allow discrimination on the basis of gender or marital status. I am a married woman, but when my father's estate is being distributed, it is ancestral land, among my brothers, I'm also entitled because I'm a child of my father. The law doesn't care whether I'm a woman, whether I'm married or not. I'm a child. And in fact, when I was a trial judge, men would come very aggressively saying their sister should not inherit because she is married. And I would ask them, are you also married? If you are married, what is wrong with your sister getting married and also wanting to have a portion of your father's estate? So that's another area in Kenya. We have developed a lot of jurisprudence, but it is anchored in our constitution and our inheritance law, but finding a lot of resistance from practice, because you find on the ground the women, especially the married women, especially those who left the family, when they come back to seek inheritance, they find a lot of resistance, but they find comfort in the law, and the law is being applied in their favor because the law does not discriminate against men and women. So I don't know, in Uganda, whether the land law discriminates against women, while the Constitution allows women to inherit, because then the Constitution is the supreme law that supersedes the land law, and what is provided for in the Constitution is what should be the law, and that is what the court should apply. I hope I'm clear on this. It's an area that we are grappling with. But the problem is the practice, it's not the law. The people accepting. So what we are doing a lot is education, public education.
Yes.
The last one, Judge Moderator, is about the NJS, the alternative justice system. When does an order made by the NJS become the order of the court? it is usually taken to court for adoption by the court, and then it is recorded as an order of the court, as the judgment of the court, and then it is implemented like any other order issued by the court. Thank you very much.
Thank you very much. I think those are very, very, very good insights, and we're grateful. I can see a hand from Southern Sudan, please.
I know it is my sister who is supposed to answer this, but I am tempted by the question. And I want to answer in the context of South Sudan. You know, in South Sudan, if a man gets married to a woman, that household belongs to that woman. If he is married to more than one wife, as there are others do, there are others who marry 50 wives, 40 wives, you see? Each one must have a household of her own. That is our custom. But in the present context, where you don't have these small households like we have in the villages, say you have a house like this, it cannot be in the name of one wife. I know a friend of mine who was married to 3 wives, and he has one house. He's an educated person, and he went and registered this in the name of one of the wives. So one of the wives came to him to say, why do you register this in the name of your wife? What if you are knocked down by a car tomorrow or next tomorrow? What will happen about this building? Because they will begin to quarrel over it. That was not the custom. It is not a good thing. Traditionally also, when somebody is married, all the children that get married, they make their own households. Boys or girls, they are married, they have their house there. The household where the parents lived belongs to the junior son. The junior son is the one who owns that place, you see? So that is our custom. Okay. But in the future, it would need to be rectified because in the town, it is not like in the village. You can have a hut and that is, they call it a home. But the situation in the towns is very difficult for one man to have so many houses for each and every wife. So maybe in the future, some laws will have to be amended to make sure that that kind of recklessness is not done. Thank you.
Yes, thank you so much, Honorable CJ. Okay, there's no hand here. The Honorable Minister.
Thank you so much. I have been encouraged by the number of questions that really touch families, and we all work for the betterment of families, each one of us, irrespective of your gender. Your Lord Justice, what you stated is what the law says in Uganda as well. But the practice on ground differs when they go now to the customs, the traditions. As somebody stated it before, the customary law, the customary ownership of land is also premised on the customary law, which customs are really patriarchal. So in practice, even when the reality would reflect that this woman is supposed to have or own something, the practice, the environment where she's married is all feels that this is an intruder, should not own. If for, God forbid, if this man died or they separated when the lady is still young, would she have an opportunity to remarry like the man would possibly also wish to remarry, and in that same land, which is customary owned, certainly the whole community would go against her. So those are the limitations. But I think our gathering here is meant to see how we can improve on the law. And for us in Parliament, we are all meant to make laws every day. So what is this new thing that we can add onto the laws such that we can reduce the conflicts and also improve on equal ownership or opportunities. Between the traditions and perhaps society, the only savior in the law is government. The savior for women and the vulnerable people is government, because traditions are really patriarchal. And the patriarchal nature does not give chance for a woman to get out and also grow and use her potential. But I think lawmakers and policy designers here can help us to bring this matter to a level where each one of us can enjoy their rights and potential. And that does not mean that we have intentions of whatsoever to subjugate men in any way, not at all. That's why, in my view, the affirmative action of 30% should also be reviewed. Why 30%? 30% is confining women to 30. And for those of us who have experienced it in the last 35 years, even when it was meant to kickstart women to get empowered or to get or share equality, we have not moved beyond the 30% provision according to the law. So we need to review this very quickly to salvage our daughters. All of you have children who are male and female. Salvage them, support them. So 50-50 would be the best way in which we can all survive and comfortably live. I submit.
Thank you, Honorable Minister. I know, Honorable Minister, that there is a draft legislation in that direction. I don't know where also it was gathered the dust in this country. It has not seen the light. We hope one day that legislation will pass. But not until you balance your parliament in terms of gender. There's a big fight in parliament. Thank you so much, Honorable Minister. And ladies and gentlemen, I think what comes out clearly is the principle of equal treatment without discrimination on the basis of gender, our cultural norms notwithstanding. I've had somebody submitting vehemently. All our legislation seem to be moving in a positive direction. If the culture is repugnant, the supreme law says it collapses. It cannot stand. So I think the call is upon us all practitioners that we should be seeking to come up with policies and practices. Those of us who are in adjudication, those of us who are legal practitioners, to ensure that we move in a positive manner without any discrimination. It has been a lively evening. I have enjoyed my work. I think I'm going to tell the principal judge to continue nominating me to represent him. It has been nice meeting with the Honorable Chief Justices. I look forward to meeting you in other forums. And those of you who have land disputes, we are ready to determine them. Thank you so much. Have a wonderful evening. There is no master of ceremony, so I turn into a master of ceremony. In the language of our former leader, I can dismiss you. Do you know that former leader? Yes, I can say I have dismissed you. So this is the closer of our gathering. Departure is at leisure. Thank you so much.
You'll always lie, you say that you love me, but you don't. Cause every time I try to build myself up, you break me down. And I'm so fed up of your promises and empty words. I need more. There's an empty space between all the words you say and the things you do for me. There's an empty space between all the plans you make, say they are for me, but they're hurting me.
It is said that in these lands only men shall cultivate these fields. So, rip my breasts out, make me a man woman. I shall bear no more children that these lands will not feed. Make me like in plant and till and take a portion of the harvest for my make so that I soar above all the taboos. I shall bear and discriminate. Make me a man woman. Through the afternoon sun to the watery. Make me a woman so I can soil my in protest for all those who once looked like me, women from everywhere. It is said that in these lands only men shall cultivate these fields. So rip my breasts out, make me a man woman. Perhaps then you will know that even women can till these lands.